I'm Don Frederico, and this is Higher Callings. In some courts, when a judge retires, their law clerks or others get together and pay an artist to paint the judge's official portrait. When the portrait is ready, there's a ceremony at the courthouse, attended by the judge and the judge's family, the judge's clerks, other courthouse staff, and the judge's friends and colleagues. After a number of speeches honoring the retired judge, the portrait is unveiled, and guests stay to get a close-up look at it, congratulate the honoree, and indulge in light refreshments. After the event, the portrait is hung in one of the courtrooms, where it will remain for many years to come. A year or so ago, I attended just such a ceremony honoring retired federal bankruptcy court judge Frank Bailey. I'd gotten to know Frank a bit through American Bar Association meetings we've attended in recent years, and monthly luncheons of a small group of active and retired Massachusetts lawyers and judges who just enjoy each other's company and lively conversation. Although it was easy for me as a relatively recent acquaintance to discover what a likable person Frank is, I learned at the unveiling ceremony just how much he is loved and revered by those who have known him much longer and better than I. At one of our monthly luncheons, Frank told me about some of the work he now leads as president of the Pioneer Public Interest Law Center. The center is a nonprofit and nonpartisan law firm that, as described in its mission statement, quote, defends and promotes educational options, accountable government and economic opportunity across the Northeast and around the country. It does that in part by filing lawsuits and friend-of-the-court briefs in cases where Pioneer believes its participation would advance these values that the organization was formed to promote. The Law Center is selective in the cases it takes, and only takes cases that it views as important to its public service mission. A few weeks ago, I asked Frank if he'd be willing to appear on the Higher Callings podcast, and he graciously agreed. The conversation you're about to hear gave me an opportunity to learn more about Frank's background and career, including his work on the United States Bankruptcy Court, his significant roles with the American Bar Association, and the important efforts he now leads as president of the Law Center. I'm pleased to share with you the delightful conversation I had with this exceptional role model and public servant, retired Judge Frank Bailey. I'm with Frank Bailey, retired bankruptcy court judge and currently the president of the Pioneer Public Interest Law Center in Boston, Massachusetts. Good afternoon, Frank. How are you?
Hi, Don. Good to see you.
I've been looking forward to this for a while. You and I have gotten to know each other within the last couple of years, and I've really enjoyed our friendship and also learning more about the work you're doing at Pioneer. And we're going to get to that after a while. But first, you've had a very substantial and interesting background. So I thought we would cover that first, and then we'll talk about Pioneer after we hear about some of the fascinating work you've done and very important work you've done both as a lawyer and as a judge. So does that sound good?
It does. It does.
All right. Well, why don't we start at the very beginning? I like to do this with my guests. I like to get a sense of where they come from their childhood days, what their background is, their family life, the early influences that drive people to end up in public interest work of some sort or another. So why don't we do that with you? Where are you from, Frank? I know you're in Massachusetts now. Have you always lived in Massachusetts?
Well, no, I was born in the Hudson Valley in Kingston, New York, where my father's side of the family goes back several generations. It's a lovely town on the Hudson River. Lived there, until I went off to college. My mother was there up until just a few years ago, so we've been back and forth to Kingston, my whole life.
What were some of your early influences in life? What kind of kid were you? Did you play sports? Did you read a lot of books? Did you have a religious background? What was your childhood like?
Yes, I guess I would start with the religious background. I attended Catholic school all the way through high school in the Kingston area. My family was pretty involved, I would say, in the local Catholic Church, in the way people are. I mean, including that my dad was on the parish council, and we were involved both socially and religiously with the Catholic Church.
Yeah.
Sports wise, yeah, the normal kinds of things for kids to do. I'm a failed pianist because I flunked out of my private piano lessons when the other guys all ended up on my porch with their baseball gloves waiting for me to finish up a painful session on the piano. And the instructor finally said to my mother, "This is not going to work." So,
Yeah.
yeah,
That's kind of the typical American boy story, right?
pretty
Piano lessons
close.
versus
Yeah.
baseball. Yeah. If you're like me, I grew up in a different part of upstate New York. Baseball at that time, at least up to a certain age, was just basically pickup. You just get a bunch of kids together and you go outside and you throw a couple things down to be your bases and you play.
That's right. There was a parking lot for a hospital off my backyard, and when the cars weren't all parked there, it was a large paved area, and that was the place where everybody would come to play. We played with those rubber baseballs,
Yeah.
and exactly what you just said. So it was easy to find me, but it
No
was
broken windows, I hope.
no. We were safe from that.
Good, good. Were there people in your family or your friends who were a major influence on your formative years?
Well, I mean, surely my mother and father both. I mean, my dad was a Korea War vet. He was college educated and worked for the local electric utility. But in the last few years, or the last 20 years of his career, he was the business manager of the Kingston version of this utility. So everybody in town knew him. He was the guy who would, when school was canceled or power was out, I should say. My dad would be the guy on the radio talking about when they expected the lights to go back on and that kind of thing.
Yeah.
And my mother was a nurse and worked at the local. There are two hospitals in town. She worked at the local Catholic hospital, which is also where she did her training in nursing. She was an RN. So, yeah, lots of positive influence from mom and dad.
So you went to college at Georgetown. You specifically the Georgetown School of Foreign Service. So I guess with the Catholic background, Georgetown is no surprise. But why the School of Foreign Service? What made you decide to do that?
It's a good question, and it's a very fair one. And the answer is going to be a little surprising. But yes, you're right. It was in my Catholic high school, the guidance counselor for the boys was a priest who was a good friend of mine, actually, and was until
Yeah.
he died. And basically, the way he handled things was if you were high in the class, then he would direct you toward Holy Cross or Boston College. And I went in and said, I've heard about this school in Washington, and I've always been interested in politics and whatnot. What about that? And he said, gee, I don't think we've ever sent anybody there. So let's take a look. When I looked over the opportunities, the various schools at Georgetown, the only one that did not have a math or science requirement was the School of Foreign Service.
Okay.
It had a heavy duty language requirement, but I always liked French, and I had taken Latin, and I thought, okay, I think I can get by that, but I'm not so sure I could do the math or science.
Yeah.
So I applied to the Foreign Service School.
And you majored in economics there.
I
What
did.
was your thinking in that choice?
The Foreign Service School is a professional school. It's almost like sort of law school. In the first year in the Foreign Service School, there are no electives. You just take the routine mandatory courses that they have, and one of those was economics. I didn't know anything about economics, but I love the teacher and I love the subject matter. And it seemed to me that of all the opportunities there, to major. Economics was something that might be useful to me later in my life, but I love the subject matter. Of course, it ended up sneaking some math into my education that I wasn't
Yeah, yeah.
really that prepared for. But so that's how I ended up as an economics major.
And when did you start thinking about law?
The Foreign Service School is, in fact, a professional school, and it prepares you for a career in the Foreign Service. And something like 40% of our line Foreign Service officers are Georgetown graduates. It's a very big influence. And so my first choice, coming out of college was I took the Foreign Service exam. I got to the second level at the time. I'm not sure how they run it today, and that was the oral exam or the verbal in-person exam and language exam. And that's as far as I got. So that was an achievement to get there. But the chances of getting into the U.S. Foreign Service were hard, very difficult.
Okay.
And the backup for most Foreign Service students was international business of some sort, often international banking. I started interviewing with Chase Manhattan Bank, and you know them all of the time.
And they were hiring people with bachelor's degrees.
They're hiring people with bachelor's degrees, and they had what was essentially, at the time, like a 1 or 2 year, what I would call a master's program. I mean, you basically studied with them. Anyway, I liked it. I didn't love it. And so that got me thinking about alternatives. And
Right.
law school that was always somewhat on my mind. You had asked me earlier about influences as a child, but in high school, I was involved with a program where I was selected to shadow a county representative. That New York has a county form of government, and they assigned me to this lawyer for an entire year. And I was just so impressed with his ability, to understand the way government and finance worked. And I was most impressed with his ability to get up and talk about, this legislation and argue, on the floor about this. And I thought, wow, that I could do. That I
What a
would like
great
to do.
opportunity. What a great opportunity to have a mentor like that and
Yeah.
somebody who you could, for a whole year. I went into law pretty blind about it, knowing very little about it. You went in and you made a deliberate choice that I've seen it. I've known a lawyer. I followed him around for a year. I've seen government work. And so when you decided you didn't want to go to a bank, you decided you'd rather go to law school. And you ended up at Suffolk. Was Boston on your radar at the time?
I looked at law schools in Boston, New York, and Washington. I wanted to be in one of those cities. I never thought about going anywhere else. So I guess I should say I also considered Albany because Albany Law School. And
Sure.
when my choices came around, my sister was already in Boston. I like Boston a lot. And I was attracted to Suffolk. And it was economically the most advantageous of the schools that I was admitted to, which at tuition of something like, I don't know, $6,000, that actually seemed to matter at the
Yeah.
time.
Yeah.
So anyway,
Well, it's a good school and a lot of very distinguished alumni, many of whom have had distinguished careers in the Boston legal community and right in the downtown Boston location. That's also very attractive. So I certainly can understand why you would do that. What were you thinking though, in terms of what you might do with a law degree? Did you have any thoughts when you started college, or did that evolve as you made your way through?
I've given you my entire experience with lawyers and lawyering was shadowing this county legislator.
Yep.
I truly didn't know what the private practice of law was about. I didn't know that big law firms existed. I didn't know what government lawyers really did in terms of a DA or an attorney general or something. So I went in a bit cold on those career options. So then, the way law school seems to work, I did well enough in my first year to make the law review. I got a job in New York City after my for that period between second and third year that summer.
Right.
And then one thing led to another. You know how that is. So,
Sure.
and then then I could understand. I knew what opportunities there were in private law firms. So,
And then you got a wonderful opportunity as a law clerk to Justice Wilkins, Herb Wilkins of the Massachusetts Supreme Judicial Court.
right.
Tell us a little bit about that experience. It's such a wonderful opportunity, but tell us what it was like and what he was like. Tell us what he was like too.
And is like, because Judge
Is
Wilkins
like.
is still with us.
I'm sorry,
Yeah.
Justice Wilkins has been around a long time at
Yes,
this
he
point, but
has.
I'm
Yes,
glad he's still with us. That's great.
all 96 years or so. But
Yeah.
anyway, but Herb Wilkins was just a complete joy to work for, and it changed my whole life. Not only from the standpoint of focusing me on working in litigation, but also on the idea of, if the opportunity ever arose to work as a judge. I thought so well of what I saw that year with him as a mentor. I never changed jobs, including when I went on the bench, which we'll get to. I I never did those things without calling Herb Wilkins and having a cup of coffee with him and
It's
saying,
so great to have that kind of relationship.
"Right, right. I know you had that as well, but
Yes.
it's just a special thing." And so Justice Wilkins is the son of. He became chief after I left, but his father was chief justice at the Supreme Judicial Court. So quite a spectacular family history,
Yeah.
and he always tried to pick law clerks that were very unlike him and unlike his background in order to have people that might bring a different experience to the decision making and thinking about cases. He made that very explicit, and so my co-clerk was from Northeastern. She was Maureen Brodoff is her name, and Maureen and I were very different from each other. But that was important to Herb Wilkins. So wonderful man.
It sounds like it was such a good experience. You would recommend it to anybody else who could be fortunate enough to be chosen as a law clerk.
You're absolutely right.
What was it that you got out of it? What did you like most about it?
It was really the first professional job that I had, and the discipline that Judge Wilkins brought to the job. He'd sort of come in the same time every day. He'd go home at the same time every day. And he'd work diligently throughout the day. And he used to say that that's the way you should run your life because hopefully you have someone to go home to and you should go home to them. That was a big deal with him.
Yeah.
So I learned I learned to get up early and go to work, and I've done it my whole career. I really think because of the way I watched him work. The whole idea of clerking, you're quite right about it. I've never had anybody say to me, I was a law clerk and that was a mistake. I should never have done that.
Yeah.
Right?
I've never heard anybody say that either.
But I've heard
Yeah.
many people say the one thing I did wrong, was I thought, oh, I'm not going to make as much money and I have that opportunity, but I'm not going to do it. And I didn't do that 1 year or 2 year clerkship. Many, many people have said that was the one mistake in my career that I wish I could go back and fix.
Some people would say that's the best year of your whole career.
I believe that. I believe that.
I tend to believe that too. What did you get out of it that helped you in becoming a good lawyer?
The writing experience. Herb Wilkins, if you go and look at his published opinions, they're probably 40% as long as the average because he was a very sparse, careful, disciplined writer, and
Yeah.
that's what he
Yeah.
wanted to see from us. I got to work on some great cases, including the constitutionality of the Prop 2.5 referendum, that petition that we adopted here in Massachusetts that limited local taxes increases to 2.5%, which was a very complicated case, but a very important
Yeah.
case. And
Yeah.
I remember working on that case extensively, with him and with Maureen. We have a system here of single justice session. So because he was Was he the newest? He might have been. He might have been the most junior judge on the bench, but and for that reason, I think he got 2 months of single justice, which was great too, because that gave you a little bit of a feel for what maybe a trial judge looks at. Things come in, they have to be dealt with quickly, an appeal from denial of an injunction or something. So that was a lot of fun. Oh, and the other thing that Judge Wilkins was big on was he would call in that same courthouse, the courthouse, he would
Right.
call one of his colleagues on the superior court who was going to have a trial. And he would say, okay, if you want to go down and work with judge somebody, on a trial, criminal, civil, you go down. And if it takes 2 weeks, you work with him for 2 weeks. You'll come up here every afternoon and when they break, and you can do your work here. And I had a chance I did motion session in the old motion session, civil motion session
Right.
that you'll remember. And I did a 2-week murder trial with a superior court judge. And so
Did you actually worked on the murder trial, or were you just observing?
no, that the deal was if I send a law clerk
Yeah.
down, you need them to do research. They're on your team,
Right.
and
Right.
that was the opportunity that we had. It was great.
And just so people know, I not many people are as old as you and I to remember back in the days when there was a motion session, but I know what it is. But maybe you can describe it for our listeners.
In the day, rather than having a session where all of your matters were heard by a particular judge and they stayed with it while they were still assigned to that session, all sorts of motions would be heard. Pretrial motions would be heard by one judge in Suffolk County, and so it was everything from dispositive motions, summary judgment, or motions to dismiss, to discovery motions, all sorts of non-trial motion. So that was what we did.
Yeah. I used to find it frustrating because what it meant was there'd be a judge assigned to hear motions on any cases.
Right.
And the judge typically would not know anything about the case until the hearing or shortly before the hearing, and then would not be following the case after deciding the motion.
You're right.
So it was very different from federal court and very different from the way things are in superior court now, where at least in federal court, you have a case assigned to a judge from the beginning to the end of the case. So that judge, there's continuity, and the judge remembers everything and has a bigger perspective on what the case is all about every time something happens. Whereas this was just in and out with emotion, and a judge would have to figure it out and rule on it without much context other than what they're reading in the papers and hearing in the oral argument. I used to find it really frustrating, and then when it went away, I missed it.
Yeah.
Because you marked up the motion. You told the court when the motion was going to be heard. And so you could be sure of getting into court and getting that motion heard within certain parameters that the rules provided. And once it was gone, you were at the mercy of the clerk and the judge to schedule hearings on motions in your cases, and it could take much longer. So it was an interesting time, and I don't think it should ever be brought back, but there were advantages to it.
The other frustrating thing about that process, I suppose, was both the good side and the bad side of this is you could sit there all morning, and wait to be heard. And they did try to call the shortest things first, but that never seemed to work out. And but the great thing about, and I know you'll agree with me on this, as a young
I'm nodding
lawyer,
already. I know what you're going to say. Go ahead.
As a young lawyer, you could sit there and you'd hear everything, all sorts of motions. I don't know if that's what you were thinking, but that was, I thought, it was an education.
Well, you'd hear all sorts of lawyers arguing,
all styles,
and you'd observe the judges too, and you'd have different judges at different months, but you could learn from the lawyers who didn't know what they were doing and got their heads handed to them by the judge. And you can learn from the lawyers who were really good at what they did and say, yeah, I want to be like that. So it had some advantages. Well, let's move on. You finished your clerkship in 1981, and then you went to Sullivan and Worcester, a Boston law firm, and you were there for a number of years. You were an associate there, and then you left and ultimately became a partner at Sharon and Lodgen, another Boston law firm. Tell us about your private practice at either of those firms, and what were you doing, and why were you doing it, and how did you like it?
Sullivan and Worcester, was a 75 lawyer firm, which made it kind of big, I suppose, in the law world. But we had offices in small office in Washington, and at the time, I think a small office in New York, and then basically Boston. But it was a great training for me, and really changed my whole career to start at Sullivan and Worcester. I'm still very close friends with many of the lawyers that I met at that firm when I first joined. They also became my clients after they went off to serve as general counsel at various companies and things. That was
Mm-hmm.
important to me. In addition, at Sullivan and Worcester, you would do a rotation in your first year through 3 different departments to see what you really liked. And imagine doing that. I don't know if they do that anymore, but did you have that experience? Am I allowed to ask you that?
Yeah, sure. It's not a deposition. I'll answer questions. So,
Did you do rotations?
no, we didn't have rotations. I worked at Hale and Dorr, and I think the days of rotations were over by the time I went to work there. If they ever even had them, I'm not positive.
Well, so I chose real estate, corporate, and litigation, and it gave me an opportunity to try out my skills in those various areas, see what the partners were like, and and was attracted to litigation. But what happened that really made things interesting for me was that in my second year, I was assigned to do the litigation part of a relatively large bankruptcy proceeding that a partner there named Barry Portnoy was managing, and I really never looked back, from that experience. The great thing about my early days in bankruptcy at Sullivan and Worcester was that in bankruptcy court, things get worked out in the courtroom, and there's a lot of roles for a young lawyer, a new lawyer, because you go over and you have a borrowing order or something. You're not going to send a partner on that. It's probably going to be allowed, but somebody's got to show up and get up and make the points on it. And so I got a lot of court time that my friends
Yeah.
in litigation, were having a hard time getting face time in court.
They must not have been going to motion session, Frank.
Yes, that's right. Yeah. So yeah,
Well, and then at some point you made the move from Sullivan and Worcester
right.
to Sharon and Lodge. Was that a bankruptcy role you
Well,
had
it
there
was
as
to
well?
start. I can explain that, but the reason I left Sullivan and Worcester was because although I was getting to my sixth, seventh year, and I realized, the name of the game here is to develop your own practice, and that was hard to do when I was working for almost all my time at that point for a very productive partner who wasn't that interested in me developing my own practice. He was interested in me working on
Yeah.
his cases. So I had run into Bob Muldoon, who was a great litigator, I'll say, really a great litigator in the city of
Yes.
Boston. He was by then at
Yeah.
Sharon and Lodgen, and I decided to go there. They didn't have a bankruptcy lawyer there at all. And so I could be the bankruptcy person at this 40 person size firm, which would bring a skill set that I thought would be, useful in that firm. And also, really, despite its size at Sullivan and Worcester, they didn't have a litigator of Bob Muldoon's reputation and practice, really.
Right.
So,
Bob was a very well-known litigator and trial lawyer in Boston, and I was fortunate to know him and even work with him on a case a little bit. And just a much loved person, such a kind of old
right.
school
Yep.
professional.
Yep. Yep.
Um,
That's
yeah.
right. So that was the reason for the move was motivated both by my economic best interest, I thought, and also my ability to fit into a smaller organization in a more important way. And I had the great opportunity there to work with people like Bob Muldoon. So it was a good fit, I
Yeah.
thought, and it was.
How long were you there?
25 years. I mean, that was the brunt of my career. So
And is that when you answered the call to become
it
a
is,
bankruptcy
yes.
judge?
So that's right. And interestingly, though, the bankruptcy world changed in those years. And all of the biggest cases that used to file sort of locally, Polaroid would file in Boston because they're a Cambridge company. Well, by the mid and late 90s, all the cases of that magnitude were filing in Delaware or New York City. And so either I was going to follow those cases and work from Boston, in cases that were filed in those cities, or expand my commitment to business and commercial litigation. So I always did bankruptcy, but it dropped off a lot just because of the liberal venue rules,
Yeah.
that drove a lot of cases out of the District of Massachusetts and out of New England. So that's what happened. And also, I never did a consumer bankruptcy case ever. It was all business bankruptcy work. You didn't dabble in consumer bankruptcy, a very different animal. So
When you were in
that's
practice.
right.
But you saw a lot of that when
Oh,
you
yeah,
got to the
80% of the
court,
docket,
right?
yeah.
You got there at a very critical time in the nation's
Right.
financial history and the world's, I suppose. 2009 is when you went on the bench at the bankruptcy court, and that was right at the time the financial world had the bottom fall out, and it took a long, long time, probably a decade, to recover from that terrible financial crisis, the Great Recession, I
Right.
guess it was called. So that had to be a busy time at the bankruptcy court. I guess I'd like to start by just talking about or hearing you talk about what that was like. I mean, becoming a bankruptcy judge just as the world was on, and the country was on the brink of
Right.
insolvency.
So absolutely, you're right on about the volume of bankruptcy filings, particularly consumer filings, and those file in Boston, for the Eastern Massachusetts, and
Yeah,
I can't remember the number of cases that I was getting, but it was thousands, of cases would be filed. And to give you an example, I would have a Chapter 13 motion session where I would have 70 motions on, and maybe 15 would come off, but then I'd hear 55 motions in a day. And I've already told you that I had to learn consumer bankruptcy, and I did.
yeah,
I if I had to stay till 8 or 9 o'clock in the courtroom, I would do it because you had to give everybody their chance. I had a spectacular career law clerk who had been there for 30 years already, who made it very, very
that's
possible
great.
for me to do this work. But I had a lot to learn when I got there. I always remember what the circuit executive said to me when we went out to lunch just before I was sworn in, and he said, well, they're busy over there. He said, but don't worry, we're not going to throw you into the deep end of the pool. And about a week later, I was saying, I think I just got thrown into the deep end of the pool.
There probably was no shallow end, right?
Yes, we were incredibly busy and plenty of business
Yeah.
cases, but my colleagues on the bench were very supportive.
So tell us a little about the bankruptcy court in Boston. How many bankruptcy judges are there? What kind of staffing is there for the judges to have support?
So first of all, I can talk more about Article 1, Article 3, but we're appointed for 14-year terms by the circuit court. And
Right.
there are five bankruptcy judges in Massachusetts, in the District of Massachusetts. And there were three in Boston, one in Worcester, one in Springfield. We had, I thought, great resources. We were given two law clerks, and you could have one career and one term. I always had a great relationship with my courtroom deputies and my ECRO, we call them, electronic court reporter who were assigned to my session, and then sort of in the back office, we would have I guess probably when I started there were five. It's all gone down in numbers, but probably five additional staff members who were taking care of getting the orders written, processing the matters as they come in. Unlike the district court, unlike any other court, it was and is a volume court. So, I always say anybody who gets to see runs into a federal judge in the United States is very much more likely to run into a bankruptcy judge than anything else, because of the number of cases that get filed. So I felt well supported by the resources that they made available to us. They're a very highly professional group of staff at the bankruptcy court.
What did you value in the lawyers who appeared before you in terms of the way they presented a case? What was effective? What was ineffective? What did you think was good and bad?
It's funny when you ask me that. I see faces. I see lawyers that I can think of as the best examples, and it's probably not good for me to pick people out, but lawyers who. The thing that I appreciated the most was when someone would come in and present both the strengths and weaknesses. They'd acknowledge weaknesses. If there's a problem, deal with it. If you have a weakness in your argument, and not lawyers who would come in and try to would either ignore those things because I'm just trying to get it right. That's all. Brevity was always, especially in the early days, I certainly appreciated brevity.
Because your docket was so full.
Yeah, I just couldn't have somebody come in and stay on for so long, but you wanted to give everybody their best shot. So, we have a policy in the District of Massachusetts in the bankruptcy court that all of us can say, because it is our policy, we have read everything before we go in, even if it's 70 motions. We've read them all. And I would always have reviewed everything, with my law clerks going into that session, whatever it was.
Yeah.
So I usually knew what those strengths and weaknesses of their arguments were, and so I could ask, but I'd always let them start. I wanted to give lawyers a chance to start and make their argument the way they saw fit first. Yeah, you do get to see a lot of styles, and the other thing that I'll say about lawyer presentations is you only get to tell the judge something that isn't true once, because you never forget it when that lawyer did that.
Right.
It's astounding. As a lawyer, you don't necessarily think that, because the line between what's best for my client and what's shadowing or shading in favor of my client is one thing, but it's you don't ever want to say something that isn't the case, because you're putting the judge at risk at making a bad decision.
Right. And I've seen that play out in some of the cases I've had where lawyers have made that mistake, and then that was it. They had no credibility with the judge after that.
And probably forever. Yeah.
Right. And not only that, but I think that judge is probably telling other judges about that person, especially if you as a judge relied on the misstatement in reaching a decision. I mean, I saw a lawyer do that once. It was in front of a magistrate judge in a very important case. And they cited case law, but they didn't cite the controlling case law that went against them. And the judge, it was an emergency motion of some kind. The judge ruled on it before my side had the chance to file an opposition. And when we pointed out, not only that it was that they were wrong, the other side was wrong, but that the judge was wrong for having relied on what they said and now had to reverse himself.
Yeah.
That was it. That lawyer had no more credibility in front of that judge for the several years that case went on.
Right.
Credibility. You mentioned earlier, owning the weaknesses of your case, and it's all about credibility.
Right.
You as the judge, and I've never been a judge. I've been a special discovery master a couple of times, and that gave me a new perspective and a little bit of an appreciation of what judges face every day. And that is that you're trying to make a decision, you want to get it right, and you are not totally dependent, but you're largely dependent on having accurate information and accurate legal analysis from the lawyers on both sides. How you apply the law to the facts, they're going to have different views of it, but you really want them to be honest with you and accurate with you. And if not, you're sticking your neck out and putting your own reputation at risk too. So,
which brings me to another issue related to this discussion, and that is when you're a lawyer and you're going in and arguing to the judge, I don't think you have the sense that, what that judge is trying to do is, as you've said several times, as have I, to get this right. That's what the judge wants to do. And so
right.
We've all had the experience of where, in the heat of litigation, lawyers are pitted against each other and they might get into tiffs, to make it sound like a nice thing, disputes between themselves. And what would always upset me, or if I ever got really angry at a couple of lawyers, it was because that doesn't help me get it right. That fight's between you two. It's got nothing to do with the merits of what we're trying to do here. And it's a waste of my time,
You're not going to get in and settle their personal dispute.
That's right.
That's not what you were hired to do.
That's right.
If you could talk about this article you wrote back in 2016. It's called, "Does the Federal Article 1 Bench Reflect the Ethnicity of the Populations That They Serve, and What If the Answer is No?" by Judge Frank Bailey. You wrote this when you were still on the bench. And maybe in doing that, just in a couple of sentences, if you can, explain what an Article 1 bench is and an Article 3 bench.
So that we're referring to articles of the Constitution, and Article 3 is the third branch. It's the judiciary. And an Article 3 judge there are a couple of attributes that are important to an Article 3 judge. And one is that they are appointed for life. And their second big thing is their salaries cannot be reduced. They are usually appointed by the president and confirmed by the Senate. So it's the typical process that we think of as, district judges and circuit judges and a few others. Bankruptcy judges and magistrate judges are examples of judges that are Article 1 judges, which is the legislative branch, so to speak. And although we are part of the judicial system, we're not appointed by the president. We're not confirmed by the Senate. We don't have those important attributes of life tenure coupled with the salary can't be reduced. So we are appointed for a term. In our case, it's 14 years. And in the case of a magistrate judge, it's 8 years, subject to renewal or extension. And we are appointed by the circuit. In our case, the First Circuit, which covers New England, essentially, and Puerto Rico. That distinction is a big one. It's an important one because even on the time that I was serving as a bankruptcy judge, the U.S. Supreme Court made a very important decision called Stern versus Marshall, where the court said, wait a minute, this bankruptcy judge is an Article 1 judge and is now exercising the judicial power of the United States under this statute that Congress has passed, and you can't do that. And so struck down that statute, which threw the entire system into a conundrum in 2011 or so. We ended up working our way through it and legislatively working our way through it. But that Article 1, Article 3 distinction is not a minor distinction. It's an important distinction.
Right. So you wrote an article about diversity on the Article 1 bench. Your article covers both magistrate judges and bankruptcy judges. You were chief judge of the bankruptcy court at the time you wrote that. Yeah, the bankruptcy court in the District of Massachusetts. Tell us a little bit about what you found and I know it wasn't just you, there were other people working on this, and how things have or have not changed since the article was written in 2016.
It's an important part of my time on the bench and goes until today. I'm still involved in this issue of diversity on the Article 1 bench. Well, it for me, it all started when I had a hearing. I had a Haitian fellow on the one side who was pro se, and I had actually a Haitian fellow on the other side, but who was represented by counsel. And it was a very easy motion that the other side brought. And I was going to, well, I had to allow the motion. And it wasn't even something that would hurt that fellow very much. But after especially the pro se individual, I let him tell me all the reasons that I should deny the motion. And at the end of it, I said, well, I'm going to allow the motion. It doesn't hurt you. You'll still have lots of opportunities to challenge what this other side is trying to do here. But it's something that I have to allow. And so I will. And I got my papers together and thought, okay, I'm move on to the next one. Mary, call the next case. But he stopped me cold and he stared at me and he said, it's clear that a black man can't get a fair hearing in front of you. And it really kind of took my breath away, to hear that said out loud, that's what he was thinking, that I had been racially motivated in some way in doing what I did. And I kept my composure and said, in what way do you think race played into this? And he didn't have a lot to say about it. But I walked out of the courtroom and I said to everyone, my courtroom deputy and law clerks and interns and row, I said, you know why he thinks that? Because everybody in the courtroom's white, everybody except him and the other side. So in a way, why wouldn't he think that?
Everybody in the courtroom, meaning the judge, the clerks, who else?
Yeah, the judge, the law clerks. In that case, for me, that wasn't always true, but it was true then. My courtroom deputy, the court reporter, the court security officers. There wasn't anybody that was employed by the court in a position of any authority that he could see. And that might have been true even in the clerk's office at that moment, that we were completely non-diverse. And it then occurred to me that all of the bankruptcy judges in the history of bankruptcy judges and referees, which goes back 100 years, there had never been, and to this day has never been, a non-white judge.
In the District of Massachusetts.
In District of Massachusetts, that's right. So that launched me into a study as to what degree does the bankruptcy bench look like the people we serve around the country. There's a lot of statistics on it, and we did a lot of work, and I published that article to highlight the fact that the bankruptcy bench was the least diverse bench in the federal system. Magistrate judges are better, but not a whole lot better. And ironically and interestingly, where Article 3 judges are appointed by the president in the political process, they were more diverse, much more diverse, even by that time, and more diverse by today's standards, certainly. So that launched me into an effort to have this recognized by the Administrative Office of the U.S. Courts, which is like the business manager of the court system. And that led us to having a number of different initiatives and programs to try to encourage non-white lawyers to practice bankruptcy. We recognize that the pipeline is not a diverse pipeline.
Meaning there aren't a lot of black lawyers in Massachusetts who are practicing bankruptcy law.
Absolutely not. That's right. There are not. There weren't then. And that's true around the country. That's true everywhere.
Okay.
I don't know why. I really don't. But we're doing better. I'll say that. And part of it was the work that we did here with this, highlighting the issue. And then it's recognized, that there's a need to have a more diverse Article 1 bench, both bankruptcy and magistrate judges. So we're making some progress there.
Good. So you stayed on the court until 2022. And at some point, I think probably while you were still on the court, you took on a number of roles. Actually, while you were on the court, you were president of the National Conference of Bankruptcy Judges. You also had the role of chair of the National Conference of Federal Trial Judges. Those were both when you were still sitting on the bankruptcy court, correct?
That's right.
I'm sure you had plenty of other work to do. Why did you decide to take those roles on, and what do those organizations do?
The National Conference of Bankruptcy Judges is our bankruptcy judge organization. It's not a government entity. It's been around 100 years, and it's we sometimes call it our union. So it's also called the NCBJ. So I think almost every bankruptcy judge in America is a member of the NCBJ and to some degree active one way or the other in the NCBJ. I got involved early because some of my colleagues in Massachusetts were very involved, Joan Feeney in particular, and that led me to work on some of the committees early on, and then, well, it just sort of rise up through the ranks. I had an interest in it. I recognized the importance of the NCBJ, both in terms of, part of it was this public outreach regarding diversity on the bench, and another part of it was making certain that there were opportunities for education of new bankruptcy judges and mentorship. And it's a really great organization. And we have NCBJ has an annual conference that where both the judges but also lawyers are invited, and there are anywhere from 1,500 to 2,000 people at that conference. So it's the gathering of the bankruptcy bar.
It's a significant role. And I assume if there's any federal legislation involving the bankruptcy courts, this is the organization of judges that gets involved in that as well.
Yep.
How long were you president of the NCBJ?
It's a 1 year,
okay,
1 year commitment.
And then also chair of the National Conference of Federal Trial Judges. So this would include bankruptcy judges, district judges, and I assume magistrate judges as well.
And all trial judges, so tax court,
okay,
court of claims, a few others. It does not include administrative law judges of the federal system, but
okay.
Yes, and it's actually part of the American Bar Association.
Oh, that is part of the ABA. But were you doing that while you must have still been a judge when you were doing that, right?
Yes.
Okay. Yeah. And is their role kind of similar to what the NCBJ role is, or is it other than covering more courts?
Yeah, there are a number of roles, of course, including public outreach as a group. When we travel to the mid-year and annual meetings, the NCFTJ does outreach to high schools. It does outreach to law schools, but also, and something you'll, as a member of the delegation, the Massachusetts delegation to the House of Delegates at the ABA, one of the things that the Federal Trial Judge Group does is it vets all of the resolutions that are coming before the House,
right,
and takes a vote, on whether we support or abstain or decline to support, a particular resolution. And the Federal Trial Judge Group also has a role in commenting on rulemaking, that when rules are proposed in the federal system, the NCFTJ makes comments regarding whether those rules should be adopted.
So now that you're not on the bench anymore, you're still very active in these organizations. You just mentioned the ABA House of Delegates. Currently, you are vice chair of the Judicial Division of the ABA. Is that right?
Well, it's starting to get embarrassing. I mean, yes, I do. I don't join everything, but it sounds like I do.
No, I think this is great. I'm actually inspired by this. So, the American Bar Association is divided into various divisions. There's a judicial division. I'm sure I don't know a tenth of what it does, but I do know I see you. I've been on the House of Delegates now for a couple of years. The House of Delegates, as you explained, passes resolutions which then become policy of the American Bar Association. Some of them pretty mundane, some of them really important. And I see you at those meetings. So we've met in various cities. I still have a fond memory of being there early at one point, and
Oh,
we
yeah.
had a weekend day in Louisville, Kentucky, and we went to the Louisville Slugger Museum together,
Yeah.
which was a lot of fun. But, these are really strong working groups. There's a lot of work that goes into these two annual meetings of the ABA. One is called the annual meeting, and that's when the House of Delegates sits for a couple of days. And one is called the mid-year meeting, which is in the winter, and that's a one-day meeting of the House of Delegates. And your work and your group actually meets before the House of Delegates meetings. By the time I get there, you guys are basically done, but I'll see you at a dinner or maybe at a House of Delegates meeting. I think it's great that you do this and that you're in all these leadership positions. It shows, to me at least, and you tell me if I'm wrong, that part of your vision of being a member of the legal profession, but also a member of the judiciary, at least now in the past tense, is really to serve the public, to serve the courts, to serve the legal profession, to serve the public, to make sure that our court systems are working well, and that also that the needs of the judges are being met who devote their lives to that work. So kudos to you for doing it. I think it's inspiring, and I think maybe at the end of this interview, which hopefully we'll get to pretty soon, you'll have a couple minutes to talk about, especially for younger lawyers and law students, the importance of getting involved in bar association activities or other groups.
I'd love to talk about that.
So, Frank, you're president of the Pioneer Public Interest Law Center. Can you tell us a little bit about that organization?
Sure. So I'll call it the Law Center, makes it easier. But though the Law Center comes out of the Pioneer Institute, which is a think tank in Boston, public interest think tank that has been around for 30 years. And what the Institute realized over the last several years is that from time to time, they were working on recruiting lawyers to file amicus briefs in state and federal court, and they were having good luck with that. They were having impact, the kind of impact they wanted to have. So at some point, they decided that it would be in their interest to create a separate 501c3 entity, a nonprofit entity, and to endow that entity and to have it serve as a public interest law firm. And that's what they did. And that started on June 2nd, 2022, which was one day after I retired from the bench on June 1,
Right.
2022.
Okay.
So
no gap.
I walked up the street and started working at Pioneer. So
That's right. You're just like a block or two away from
that's right.
where the bankruptcy court is.
Right.
What is the mission of Pioneer Public Interest Law Center?
So it really is three things that we're focused on. Probably the largest commitment we try for is educational opportunity and education equity for kids in public schools and perhaps beyond. We also have a focus on equal economic opportunity, attacking situations where there's unfair, undue regulation. So free markets is another area of our interest. And then the third area is free speech and civil rights kinds of things.
So it's a nonprofit organization, and it, as its name would suggest, it serves the public interest in the ways you just described. I know you weren't the person who founded it or one of the people who founded it. That work had already been done before you joined, but I'm sure you can tell us a little bit about why someone saw a need or an opportunity to form an organization to take on those kinds of cases.
So again, that's the Pioneer Institute board was behind this.
Right.
And in particular, our chair is Brackett Deniston. And Brackett, who's currently a lawyer at the Goodwin firm, but was counsel to Governor Weld, Bill Weld, and then for many years the general counsel at General Electric Company down in Connecticut.
And early in his career was also a federal prosecutor, I think, when
That's
Bill
right.
Weld was U.S. attorney.
That's exactly right. Yep.
Yeah.
So I think it really was it was really Brackett's inspiration to have an adjunct to the Pioneer Institute, and he saw, as did other members of the board, that what the think tank works in pretty much the same areas of our mission. And they do studies and they do public education, about those topics. But from time to time, that's just not enough. And it's either in the public interest to have lawyers file briefs in amicus cases as amici or even initiate litigation. And so that was why it was founded. And by the time I got there, the board was in place, the initial board anyway. Their first official act was to hire me.
Yeah.
And it's been great. It's 2.5 years, and we're doing great.
Yeah, it's an interesting organization to me because I used to serve on the board of the New England Legal Foundation. And at first, when I heard about the Law Center, Pioneer Law Center, I was under maybe the misimpression that its mission was basically the same as NELF's, and why do we need two NELFs? But they are different organizations. First of all, you have 3 very specific target areas that I don't think are necessarily laid out for NELF. But also, NELF only files amicus briefs. At least that used to be the case when I was on the board. And you not only do that, but you also will initiate litigation if the case calls for it. Am I right about that? Was there some recognition, do you think, that, gee, there's already an organization doing some of the kind of work that we want to do. Do we really need to form another one?
Oh yeah, and there were extensive discussions with NELF and the NELF board, and in fact, Brackett Denniston is a longtime member of the NELF board,
Yeah.
as are several of our board members. But the distinction is, as you've identified, our mission's a bit broader than NELF's. And secondly, we initiate litigation. And we have actually coordinated with NELF on occasion where they have come to us and said, if you file this case, when it gets to a motion to dismiss or something, or certainly on appeal, we will file an amicus brief. But somebody's got to bring this action that needs to be brought. So we've actually coordinated with them.
So one case I do want you to talk about is the equity theft case. You and I spent some time talking about those cases or that issue as
Right.
it was all percolating. And after the Supreme Court had decided a case that really raised questions about the validity of a Massachusetts state law. I'm not going to steal your thunder. Can you just summarize the case and what role and why we all should be grateful that Pioneer is out there protecting our economic interests as citizens of Massachusetts?
Well, that's right. And that falls within that, economic opportunity fairness strand of our commitment. But there's a little known and shocking, in a way, statutory scheme that 13 states had, where if a homeowner fell behind on their real estate taxes, even by $1, but say make it real, $500 to $5,000, but their property, that real estate, was worth $300,000, the city or town was permitted to foreclose on the tax lien that emanates from the failure to pay those taxes, and to keep not only, like you would in a mortgage foreclosure, not only what the city or town is owed in taxes, but all of your equity. So a city or town could take $300,000 in value away just to pay a $500 or a $5,000 lien. We filed a brief in the U.S. Supreme Court that considered that issue. It's called Tyler versus Hennepin County, Minnesota. And the court agreed with us and with Ms. Tyler in that case. She had lost significant equity in her home. And the Supreme Court said that violated the Fifth Amendment. It was an unconstitutional taking. So then a lot of people said to me, well, that ends it, right? Massachusetts can't do that anymore. Well, the reality is you have to have that case involving Minnesota applied in Massachusetts. So through a number of cases that we brought, trying to test the applicability of Tyler on our Massachusetts statutory scheme. Ultimately, we were successful. We brought a direct action at the Supreme Judicial Court in a case called Mills versus the city of Springfield. We were able to get a ruling. It was referred to a trial judge for an initial ruling. That trial judge agreed with us and said that our Massachusetts scheme was unconstitutional. An example there, why would somebody do this, right? The answer is Ms. Mills is a good example. Ms. Mills is a young single mother, inherited her home in Springfield, which is worth, say, $250,000. By the time she inherited it, there was already $2,000 in back taxes. She is a handicapped person. She works full time, and her mother lives with her. And she kept trying to work out a deal with Springfield to pay them back over time, but cities and towns have little incentive to do it. So they didn't do it. And ultimately, they were about to foreclose on her home. And that's when we got involved and brought that action to stop that foreclosure proceeding. That resulted in, finally, 2 years later, the state legislature finally revised the statute. The statute, we call it the equity theft statute. They don't like
Right.
that, but we do.
Yeah.
Because it is. And we have, I think, probably a model statute, frankly. We have a very good statute now in Massachusetts that protects the right of an individual to receive the value in their home. City and town still gets paid in full with all the interest and attorney's fees and everything else, but the net value goes to the individual homeowner. So.
Yeah, I'll say when I learned about these cases, I just thought those laws were the craziest laws and most unfair laws I'd ever heard of. And I think it was wonderful that Pioneer stepped in. And you not only filed complaints in court, I mean, this was not just an amicus brief. You were actually representing the complainant in this situation. But I seem to recall, Frank, you were also meeting with the legislature to get that law revised. You were very much involved in that process as well. Is that right?
Yeah, so we partnered with Greater Boston Legal Services, the ACLU, the National Consumer Law Center, and all these groups together made visits to the state legislature, sat down with members of the Senate and the House, and helped with the crafting of the legislation that ultimately was adopted. So, yeah, that was great fun for me. That's outside anything I've done before, frankly, but interesting.
Again, thank you to you and Pioneer for doing it. I guess I'll say this at the risk of speaking out of turn, but when I first learned about Pioneer and read its mission, and I think the words free markets appears somewhere in the mission, I kind of assumed Pioneer is a conservative, Republican-oriented organization, and it's going to come at things from a right-leaning perspective, and maybe to some extent it does. But the cases that you've been involved with aren't really political in that sense. They're really seeking justice, and I know your organization is a nonpartisan organization. But again, it's not. You're not doing something political. You're doing something to achieve justice for parties that are actually being injured by unfair laws, regardless of whether somebody views that as a conservative or liberal thing. So kudos to you for doing that. I think it's important that people understand that about your organization.
We are very careful in the cases that we select to make sure that we don't get involved in things like I call them the culture wars. We've had, because we do student rights and family rights in school, I've had people call and say, my kid has to read this book and I don't think that ought to be in the library. I'd like to have it removed from the library. We won't touch those kinds of cases. We will try to refer them out, sometimes, because everybody has a right to a lawyer.
Sure.
But that isn't something that we would do. So, yeah, we consider ourselves extreme centrists, politically, or apolitical is probably a better way to look at it.
So I think anybody who's listened to this episode of the podcast all the way through will really get a sense of you, Frank, as somebody who has really represented the bar and the bench very well. You've not only had a terrific career in private practice, but you have held leadership positions both in the bankruptcy court in Massachusetts, on the national stage for federal trial judges. You're very active in the American Bar Association at leadership levels, trying to establish laws that promote justice and fairness at all levels of our population. And you've taught, which also to me is one aspect of professionalism. When people get to be our age, one of your big goals in life especially is to make sure you're doing something for the next generation that follows you and helping prepare them for their careers and their lives. To me, that's all an aspect of professionalism that you exemplify very well. What is your vision of professionalism for lawyers, and what do you tell your law clerks and young lawyers that you work with and that you encounter about their obligations and opportunities to give back to the profession and really to their communities and to their country?
I'm glad you asked that. It is an important part of our obligation to mentor, in my case, law clerks over the years, and in other instances now, lots and lots of interns, that kind of thing. I always say to them that, especially the interns who are law students, who I so enjoy working with and get so much value from, I'll always say to them, at the end of the day here, you're going to take the bar exam and they're going to hand you a license. And with that license, you can do so much good. And it can be so rewarding in your life, not just with winning cases for people, but creating value for people if you're doing business kind of transactions and things. But always find a way to have an opportunity to represent people that are underserved, because that's the most rewarding thing that you'll find. And you'll miss out so much in your career if you don't take that opportunity.
I couldn't agree more, Frank. And I think that's a really good place to end our conversation. So thank you for a very inspiring conversation. And I'm sure other people who listen will find it inspiring. And thank you for all that you're still doing for the bar and the bench and the people of the great Commonwealth of Massachusetts.
Well, thank you for doing this. This is a wonderful podcast series that you're putting together. I've enjoyed meeting and talking with you today, Don.
Well, it's a great pleasure for me. So, all right, Frank, thank you again, and I'm sure we'll see each other before too long.
This has been an episode of Higher Callings. Your host is Donald Federico. Music is provided by Fancy Mountain, and our logo was designed by Matt Pedro. The associate producer is Brian Federico. Higher Callings is a production of Federico Media, LLC.